Hello and welcome to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know in that same question tool and we will do our best to resolve them. And finally, just to note, the recording of this session and accompanying slides will be shared via email in the coming days. So, without further ado, I'd like to hand over to our speakers.
Good morning, good afternoon, and good evening to all of participants in this webinar. It is a pleasure to be here with you. I would like to start by setting us in the appropriate context, which means that I will take you through some main ideas of the due diligence. When we talk about a concept of due diligence and without recurring to a textbook definition, I will be inclined to say that a due diligence is a verification process involving a person or an entity, or it might involve assets or rights in order to assess its degree of compliance with the law or the applicable standards. When we talk about due diligence, we have like a general concept like the one I just outlined. And in this sense, it is worthwhile mentioning that such verification process may take place as a condition for the realization of a deal of any sort, be it a straightforward contracting, for example, a lease agreement or a buy-sell agreement, or it can be even ordinary and mundane things such as opening a bank account, where the bank actually carries out a diligence process of a customer. However, for purposes of this webinar, when we refer to due diligence, we refer to the process that takes place prior to or in the context of a merger or an acquisition. That is a deal where a person, in its broadest sense, is interested in acquiring or merging with another person. Thus, a due diligence process will serve the purpose of letting know a potential acquirer the degree of compliance of a target entity, especially considering that in one way or another, the potential acquirer will take on any liabilities derived from such degree of compliance. This as a general rule, because naturally we can understand that there are some liabilities that can be addressed particularly by the parties to one of these processes. When we talk about due diligence, it is worthwhile also mentioning that there are types of due diligence. Again, we can find, for instance, a financial due diligence, which we could say that it's the process which is focused mainly on assessing and verifying the financial condition of a target entity. In other words, it aims to verify if the numbers presented by the target entity are accurate by revising the financial and accounting information. There is also the legal due diligence, which is the one that is the most important for our webinar today, which is the process that focuses on assessing the degree of compliance of the target entity with its legal obligation, either these obligations that are derived from the law or any agreement to which the target entity may be a party to. It usually focuses on the following matters of the law, which I will mention here and address some of them only by way of example, because it can involve other areas of the law. First, we have the corporate area. This has as a main purpose to examine and revise corporate records. An example of this, for instance, is the verification that the shares or the quotas have been adequately issued and that the parties purporting to be the owners have actually a legal title to them. and that such title is adequate and sufficient as per the applicable law. Also, under the corporate matters, we will revise, or advisors will revise, the decisions of the shareholders' meetings or other relevant corporate bodies that have a bearing in the decision-making of the company. In this aspect, we might find some correspondence or connection with the G in ESG, given that the corporate bodies are source of decisions and thus a source of governance. We also have a regulatory aspect. Depending on the nature of the target's activities, there might be a requirement to have permits, licenses, or specific authorizations that must be in place in accordance with the law. And naturally, as part of the diligence process, this needs to be verified. In here, we can find some correlation and correspondence with the E in the ESG, particularly in the case of environment, assuming, for instance, that the target entity's line of business requires it to have environmental permits, approvals, or licenses in place. Leaving aside for a moment the fact that more recently, it's almost expected that entities without a specific line of business dealing with the environment have a certain degree of care and conscience regarding the environment. Also, in this part, it is important to mention that there might be some operative standards in environment matters that perhaps might not be legal requirements, but are standards nonetheless, which will be addressed later on during this presentation. Also, we have some verification of contractual matters, which basically means revising the main agreements of a target entity to see what are the obligations and rights for the relevant party. And in this context, it is important to revise if there are any clauses that might have a bearing on the potential deal. We're talking about, for example, change of control provisions. Also, the due diligence involves a review of the labor aspect of a target entity, in which it is verified whether the target entity is in compliance with its labor obligations as derived from the law. In this aspect, we again find some correspondence and connection with the S in the ESG, because employers in general are obliged, among others, to provide a safe and healthy working environment for its employees. And in this particular sense, it is important to bear in mind that, as a matter of fact, ILO recently declared safety and health in the working environment as a fundamental right at work. Also, we will find that tax and the tax compliance is assessed as part of a due diligence process. Also, data protection and compliance per se might be interesting areas of a due diligence process. And I say might be because not all legislation have data protection regulation. Nonetheless, some legislations, so some countries that do not have a data protection regulation will have some standards that, or may have some standards that might be worthwhile revising. Compliance here we are understanding it in the fulfillment of the obligations of the company, general legal obligations. Again, here we find some connection with the G in the ESG, as compliance with legal regulatory requirements and to an extent community requirements is also requires a fair commitment from the governance of an entity. Please, if you could change a slide. To the next one, please. Thank you. So when we talk about phases of a due diligence process, we are referring basically to a preparatory, or initial or preparatory phase, where a due diligence will commence once there is a preparatory document or agreement in place. Let's say an LOI, a letter of intent, an MOU, memorandum of understanding, a binding offer, or something similar that provides an adequate framework for the flow of information. Confidentiality is naturally of the utmost importance, and this is regulated via a standalone NDA or by introducing the relevant non-disclosure or confidentiality obligations in the preparatory documents. Once this working framework has been established, usually a due diligence request list is submitted. And when we talk about a due diligence request list, it's basically a list that is presented to the target entity where documents or information is required. A few notes about the due diligence request list is that it should be relevant and pertinent, but also clear. And I mean, or at the end, the due diligence request list should ask what is expected as per the line of business of the target entity, and the requirements should be drafted in a clear and understandable fashion. Here there is an art perhaps of balancing the goal of doing a comprehensive due diligence in an efficient fashion, especially time-wise, because nowadays the duration phases for the duration for these phases is to an extent limited. It's not like an open phase where it can last months, because these are to an extent limited in time. The provision of information typically will be done via feeding a data room. Most likely it will be a virtual data room to avoid the photocopying of documents or printing out long documents. These documents are usually scanned and they are uploaded in a virtual data room that is usually located in the cloud. This data room will be available for consultation to the advisors and the designees of the advisors. The documents in the data room can be digitally structured to mirror the confidentiality provisions. For instance, a document that is downloaded from a data room might display in a watermark who downloaded it, in what date and time, and whether it was printed or not. In some cases, these measures might even go a bit further to protect the confidentiality. And for instance, even if documents were downloaded, they will not be accessible after a certain date. The revision of the documents in the data room is expected that will provoke some questions from the advisors, and a Q&A process is part of the diligence process, a Q&A phase, and it can take various forms. For instance, all hands call can be organized between the parties so that the questions can be presented and the answers can be provided in that call. Another way, it's having basically a Q&A tracker, which is shared and then shared with the target entity and then returned to the advisors of the potential acquirer. And also, it is typical that nowadays these phases are limited, and in some cases, the number of questions can also be limited, especially in competitive acquisition processes. Then there is the issuance of a report which basically the advisors, after they had revised all the information requested in the due diligence request list and that was made available in the data room, they will produce a report signaling red flags. Red flags understood as those that will have a bearing in the intended deal. What is a red flag? Typically, it will be that which has a bearing in the potential deal, but the potential acquirer can set the standards in advance for establishing what is a red flag, and those standards can be in the form of monetary thresholds, for instance, where basically these are stated at the beginning of the process, and the advisor that red flags will be reported if they feel, or findings will be reported as red flags if they encompass in certain characteristics. This report is typically presented to the interested party, to the potential acquirer, but it can be also presented for the benefit of the bank if there's like a financier, or nowadays that has been more common, an R&W insurer, which is basically an insurance of the reps and warranties. So the reps and warranties in the context of an SPA, which will be insured by a third party. This third party must have the findings report in order to assess the likelihood thereof, and naturally it will be the guidance to establishing the price of the insurance for these reps and warranties. Please, if you could change to the next slide. Thank you. To conclude, I think we can summarize as follows. Due diligence is a process. A legal due diligence is a process that is intended to verify the degree of fulfillment of a target entity with its legal and contractual obligations. This conclusion might have some considerations that Roberto is going to explain further on. For purposes of this event, we might say that due diligence occurs in the context of a potential transaction, be it a merger or an acquisition. The purpose of the due diligence process is presenting the interested party or any other third party mentioned earlier with the diagnosis of the potential target entity or the target entity, so that the interested party can evaluate moving forward with the potential transaction, or moving forward with the potential transaction absolutely, or is perhaps stating some conditions on which is willing to do the transaction. For instance, price adjustments, escrow agreements, holdbacks, among other, which are not the main subject naturally of this event, but which are important, bearing in mind by virtue of the findings that can surface in the due diligence. Also, along the last minutes, we have referred to certain areas of the due diligence process where either the E, the S, or the G are present or relevant. So now it's time for my colleague and partner, Roberto Cordero, to take us more in depth in the fascinating waters of ESG. Roberto, if you will, please.
Thank you, Luis Pedro. I hope everybody is having a great day today, afternoon, or evening. Thank you for so many people to acknowledge this presentation and to join us with this ESG main topic that has taken the world by storm and that has influenced now even the financial sector and the legal sector. A lot of the big consultant companies have performed, and big law firms, due diligence studies based on much what Luis Pedro explained to us, especially checklist, red flags, due diligence, and summarize in reps and warranties on regards to the environment. What we are going to present today, and where we're trying to open your mind into what is really on-site ESG perform due diligence, is not the usual checklist, it's not the usual red flag that will end up in a reps and warranties, and that for acquisitions might represent bigger contingencies, as we see in the final slides today, that can represent even more than 70% of change in actual value of the transaction. And why is this? It's important that we can go through the first stages of this slide that we're looking at right now. And we can only review documents, permits, and see what's on the data room. But what mainly happens when you are trying to analyze and to give quality and quantity to what are the environmental and social impacts, site inspection is a must. That's why on the center of the slide, you can see where we're trying to present today to all of you is that the visual inspection and probably the determination of sampling not only soil, water, but other environmental and social impacts of the operations might end up being actual contingencies that may not even be in the results of the reps and warranties. And why is this? You have to understand that every operation, every industry, every hotel, resort, property that's going to be acquired, it's going to be reviewed, might have always some impacts that have been overlooked by authorities. Not only in our region, in Central and Caribbean, because we have performed these studies also for South American companies and in South American countries and in the US, but especially because the composition of the climate, of the soil, of the properties, of the coastline, of the range of mountains is totally different when you're looking at exactly what the operations might have taken into consideration as impacts and what have they told to the authorities and result in permits or reports that you can review at a data room. For example, if we do the analysis of the water capacity, most of the time there's no baseline studies that will let us know not only the capacity of the water sources used by the operation, but the quality, the source, and if we're looking for business continuity issues, this might represent true not only obstacles, but investment or investigation that had been to perform not only by sampling these water sources, but to acknowledging the responsibility or the new legislation that, for instance, in El Salvador, Guatemala, and Honduras has been approved on regards to water law. And what are these requirements, as Luis Pedro was pointing out, that maybe the industry, if you're coming from medical devices company or you're coming to a food factory, might require further evaluation of water and air emissions and sampling that will be acknowledged on regards to the industry's target. And this is a must because the sampling not only has to be made on the site, but has to be made with accredited labs that will suggest not only regional standards, but international standards to be accredited their results. In this sense, when results are gathered in and are ready to be reported, some issues might come in the way to evaluate if this actually is a contingency, if it's actually the need to invest more in this operation, or if what you're buying really, or you are acquiring this operation has not seen the capacity for business continuity on regards to environmental issues. Not only that, but if we go to the social contingency and we are evaluating the exposition that people had for years and years of good and bad regulations in our regional countries and with the legislation that was set up until 2021, we might find out that there are contingencies that are not likely to be seen, because work labor have been exposed to dangerous emissions, heat and temperature risks, control of non-standards for emissions on the workplace. As Luis Pedro has pointed out, the International Work Organization has established that now safe and security measures are a human right. On these regards, we might even be buying a company or acquiring an operation or an industry with a huge contingency on regards to labor expositions to environmental risk on the workplace. And this could be set up as unsafe conditions, but how can this be measured on the long term if you're acquiring an operation that can have 10, 20 to 30 people working in a specific line of production which had been exposed to these safety, unsafe conditions for years and years to come. So basically, not only the sampling, but to know the industry, to understand the risks, and to see it not as a requirement from the labor law or from the checklist that Luis Pedro was pointing out to us, but to understand that maybe the conditions, especially in our region in Latin America, can be set up to comply by legislation, comply by regulations, but not to the standards that maybe are required in the industry worldwide. And this is why it's so important an on-site inspection. As The Economist was setting up in some articles these past days on regard to ESG, to be measured is to be wise on regards to the quality and the quantity of the impacts that really on regards to labor and to workforce we will be looking at if we're trying to do a new perspective on due diligence. You can set up this as rep and warranties and put some of the investment aside for further information to come on the line of time after you acquire the operation, but the risk is too high for not to do the inspection and not to do the site field analysis to really understand what are the true conditions. So basically, what we point out in this slide, you can also be aware of soil sampling, because the infrastructure has been built on a site that had construction permits, but it would have been a land that was filled with debris for cheaper cost or for easier development. And maybe some of these samplings can have to do with infrastructure capacity and the capacity to sustain the industry that's on the target to be acquired or to be of a target of the due diligence. Hazardous waste and wastewater has also had new legislation in all of Central America and the Caribbean. And in these regards, on-site inspections are a must to find out if there has been underground management of this waste by the actual owner or the past administrator of the industry that's looking forward to be acquired. On the next slide, please, we will see a little further how this is set up. Not only the evaluation, the sampling, but fortunately, the corrections or the remediation plan. So in the next slide, we will go phase by phase and try to not only see the legal documents that are so important that Luis Pedro was so thorough in explaining that to us, but that could not only be a surface report or a document report that can not be seeing all the consequences that from an environmental and from a safe workplace should be looked at. That's why phase 2 of a due diligence is always recommended to really reassure not only the investment, but the capacity of the of the company doing the due diligence, either is a consulting company or is a law firm that has its good environmental department and ESG department, but to really work with labs that are accredited. So the gap when the closure comes has the recommendations and has determined the capacity for business continuity, as not only is important to acquire the good price of the company or the industry that's been on this merger or acquisition on site, but to understand what are the contingencies money-wise, environmentally wise, and especially on the workforce if you are acquiring health and safety issues that will result in consequences 5, 10, 20 years on the calendar. So the most important is to go and to give all of you attending today an added value for your time. So that's why we prepared the next slide to understand better phase 2 and phase 3. Phase 1, as Luis Pedro explained to us, it is the usual review the reports, review the permits, review the responsibility, check out the site, see if there's geological, environmental, water studies. If there is presence of this, then maybe you can find it at an environmental impact study if there's an institution such as it is in our countries these days. But be wise that the information set up on these institutions might have to be updated to what is really happening on site, and that's why we will see further on the information that we'll provide. The current legal status is always on regards to this list, to these procedures, to understand the permits, to understand the legislation, but maybe some complaints to the Ministry of Health, to environmental courts, or even criminal cases might have been to review on regards to many contingencies that have been filed against the operation for years before the actual merger and acquisition. That's why in the next slide, we provide a very on-site inspection on regards to some standards. As some of you might know, ISO 14031 and ISO 19011 are two of the standards that are used for this type of reviews. There's even the EPA Inspector Field Manual that has been updated to a Central American and Caribbean version in work with the APA from the US. So basically, if you are thinking of providing these type of studies, it is important to understand that there's a standard not only from the legal point of view, but from the industry point of view, and the requirements that the market where you are looking forward to have an impact with buying or selling these companies or these entities might be a need to understand, not only for business continuity matters, but to understand if that really industry has the water capacity to keep producing those food-related factory products, or if this is a medical device company that has been in operation in our region and has to comply with not only FDA regulations, EPA regulations, but medical devices requirements, as we can see in the next slide, please. Basically, when we go to phase 2, it is important to understand now what Luis Pedro explained to us on regards to legislation. But it is important also to understand that maybe some baseline studies are not information that you can gather around. There's no baseline studies for soil sampling. There's no baseline studies for water or groundwater studies. And it can result in reports on the quality of the water being used by the company, but not on requirements, of how deep is the aquifer, what is the hydrogeological capacity of it, if we are just buying a company that might be out of business in 5 to 10 years because there will be no water in the region because there's a risk of the aquifer or the capacity for it to produce, or even the place where the wastewater is being deposited or is being discharged. If these water bodies are now being enforced by new legislation, and it's just happened in El Salvador this month of July, that there's a new legislation that required environmental, even we can say environmental taxes on further on the line that will come back as hidden costs that maybe the team that's advising the merger and acquisition hasn't looked forward on the line to understand that in 5 to 10 years things can really change, and this could represent 20% of what the company was worth because of new water regulations on regards to these issues. Air emissions are also updated on our region, and it is important to understand not only the legal requirements, but the health and safety requirements on regards to the workforce that had been exposed for years and years of this type of emissions inside the industries or outside from it, and that could represent contingencies with even the communities around the sites or the industry have been bought. Not only thinking about industry or factories, but thinking also about resorts, especially from tourism boost now that we are looking forward to get out of the pandemic and COVID-19 issues. But because so much investment is coming from Europe to buy hotels, resorts, and go into tourism, water issues are a must to review on regards to communities and the pressure to the aquifer and the capacity to provide the water for these business continuity issues. So not only the technical aspects we wanted to put here on regards to the sampling that you will get from part of the information that we'll provide all of attending today, but only to understand the social part of it and the capacity of the community to react when they know that there can be in the water quality reports issues on regards that effects from our industry or from the industry that we are reviewing might result in some requirements that would have to comply with social issues down the line when the calendar goes by and people acknowledge that there has been exposition to air emission, water controls, or wastewater discharge. Soil analysis is very important, and soil analysis, you not only have to review the infrastructure and the capacity of the site to sustain earthquake or seismic risks, but to understand if there was not the best support for the structure of how it was built, but only to understand if there's archaeological, cultural, or even as we have in all of South and Central America, uh, Indian and cultural archaeological issues that had to have hearings, had to have communities taken into evaluation, as happens a lot in Colombia and in the rest of South America because of Indian reserve areas, especially with mining companies and mining industries, but especially again with having the 169 convention from the International Work Organization. They have the capacity to ask for hearings, ask for being represented if some of their issues might be on risk on regards to soil management, or that the company will be looking forward to acquire new land and to expand its operations, and they are set up in a place where these requirements are also have to take in consideration. But coming back to what the slide provides, soil sampling with the exactly labs that have the accreditation is a must. to have not only the true risk of what is being bought or what is being invested in, but to understand if there has to be environmental remediations. And that's why we have to go to the next slide to understand and to move forward because we're getting close to our final time. So some recommendations here in regard to the sampling that we did on the last slide. We will have to start preparing remediation plans if there was water issues, soil issues, or air emissions results that were negative. And the remediation plan must have a quantity of how much it will cost a new wastewater treatment facility, a new boiler system because it didn't comply with new regulations on air emissions, or if we have to look forward into mitigation actions because the institutes or the government has changed regulations and is asked now for this international investor to come to our region to buy this operation to comply with new regulations on regards to mitigation. So remediation has to take in consideration not only this technical information, but also if there had been sanitary orders from the Ministry of Health, permit cancellations, or even new regulations that just happened in El Salvador on regards to water concessions, where the property of the water concession can be translated, but with rights or without the rights of the actual owner. So these issues had to be taken in consideration in regards to remediation plan, and of course, this will touch the cost, and this will unfortunately change as we can see further in the presentation in our conclusions. Almost 70% of the cost when you are performed through environmental or ESG due diligence. More than 70% of prices can be changed on regards to actual resorts. So in the next slide, please, we will see samples of what is follow-up on regards to this. This phase 3 not all the time is contracted for the studies because the new owner or the company that's doing the acquisition might have its own team to do the follow-up. But it is important to understand that that can be supervision from the consultant or law firm that performed the due diligence on regards to having the supervision follow-up and taking in consideration all the results from the lab sampling and baseline studies that were performed. So in the next slide, please, when we are presenting the closure of the actions, this small diagram will let us understand a little bit easier how this process would be. As Luis Pedro explained to us, we could have just the due diligence with the reports, review, and legal regulations or permits, and then most of what environmental, social, and governance red alerts would be set up in reps and warranties. But if you perform already the field inspection and have the findings, then you could have the correction of it, the remediation process, and a successful business transaction. Or even you perform the remediation process, and because of the cost of what it would be to do the remediation, then business would be terminated. So this diagram, I like it very much, and it will be very helpful for your work as all of you attending today, because it will help you to understand how to move further into findings, remediation process, and a successful transaction. Next slide, please. As I was pointing out, and these are KPMG data that we look forward, and this is 70% of due diligence or environmental due diligence with ESG standards have direct risks on the cost of the transaction, and 50% require remediation plans. And even after remediation plans are set up, more than 30% of investment is needed on regards to these real and true on-site ESG requirements. Not only, as Luis Pedro pointed out, on regards to work and labor issues, but on regard to water management, soil reposition or remediation, reputational and client risk, and also uncalculated impacts that might further in time attempt to business continuity of the merger and acquisition. So we plan to give you time for questions, and so I think we have one more slide for our conclusions, please. Luis Pedro.
Yes, thank you, Roberto, for the very interesting explanation. I think, as a matter of fact, and as the webinar actually says, this is a new perspective that really reshapes the due diligence process as we knew it and as we typically implemented it. So a couple of things that I keep from your intervention, Roberto, is it is important that by doing this process, other liabilities might surface. And naturally, as I explained when I was speaking, these liabilities or these risks can be dealt with in the acquisition agreement, and some might be harder to deal with or to find an appropriate solution that might even bring the business down. Others might actually, due to their nature, allow for the parties to reach an agreement as to how they will handle it. So I think that's very interesting. And I think that the main challenges that the due diligence process faces in the context of the ESG or this new perspective, one of them is that the industry standards develop faster than legal requirements. So the law actually is not at the same pace as the development of the industry, yes, and thus of the industry standards, which has naturally very important consequences on the due diligence processes.
And I think that point that you made up, and looking forward to questions from the audience. Our region is a very interesting environmental and climate lab, if we wanted to put it this way. And that's why most of the Fortune 500 companies have operations here, especially medical devices companies, because they understand that the difference between requirements and regulations can be managed by the industry requirements. And in that sense, they will comply with legislation in our region, they will comply with legal standards, but they will have their own standards, which could be higher than the regulations in Central America and the Caribbean, even in South America. And that is important to understand, and it happens also in the US, as we have performed this work also there, and understand that further into the development of industries, requirements might be getting up and up on social and safety, requirements on the workplace that cannot be looked at by the legislation, but by the requirements. So I think that point that you made is very important.
Yeah, and the other one that we can sort of conclude here is a standard may not be a legal requirement and still have legal consequences. So perhaps a standard, as it says there, it's not legally required to be observed, but the absence of observing it might trigger legal consequences, as it might happen in certain regulated industries or industries that are very specific, of a very specific nature.
Yeah, and especially on regards to food factories or companies that had requirements on regards to this the FSSC 22000 standard on have to comply with FDA regulations and have to comply with the market requirement from Europe or from a specific country, and these requirements might even be harder on regards to water sampling, on regards to air emission controls, on regards to chemical management and waste management. So in this sense, it is important to acquire a team that has the knowledge to perform this due diligence, so these requirements will be looked on this sense and will be reviewed not only from a legal point of view. So I think that is very important and could represent a higher cost at the end of the report. I think looking to questions and looking to have attendings participate, we are very happy to have so many people from so different sectors, and we will glad to have your questions now or to write to us. We here in Arias will be more than glad to help you, and we are prepared to be having these conversations with all of your teams. And I like to thank Lexology for this opportunity. I don't think we have too many questions.
I see one question here, Roberto.
Okay.
Yeah, let me read it just as it came. It is clear that companies that operate on highly regulated industries must have all environmental permits in place. But how do you see ESG shaping the operative standards of companies that might be deemed environmentally neutral, if at all possible?
Standards are the top of the line, and this question is always important because you don't know where the market will change and will ask for new requirements. So to have a strong ESG approach is not only safe on regards to merger and acquisition, but is the quality and the top performance that the worldwide is being looking forward for the marketplace. BlackRock, as one of the biggest investors, has set up these standards on regards to the bank industry and has pointed out, if there's no sustainable reports on the companies that I want to invest them on, then I'm not interested to invest in them. And this is from a financial point of view, not even from an ESG point of view. So if we look at the sustainable reports and how these have been issued as a requirement, it is important to understand that is top performing, that the companies have to look and not settle for the lack of legislation where they're operating. So this will always be a win-win situation to look forward to have this performance updated.
I think it's like a forward-looking approach. Be prepared and ready at all times, because you don't know when all the standards will actually become law. And
exactly.
the law naturally gives a transition process or phase or time, but it's better to be ready in that sense. I see also one other question here, and if you don't mind, Roberto, I can take I can attempt an answer there, and you can complement it. How do you see ESG? How do you see ESG modeling and influencing the granting of finances? And this is very interesting, because actually it points to a reality. We had the idea that only international finance was to an extent driven by ESG standards, and that only in this international finance agreement we saw all sorts of commitment to the environment and to social of a social nature and all that. But we have seen recently in the local finance agreements as well that local banks tend to put all these sort of obligations of covenants in the loan agreements. So it has become was international at a time, but now it has become a local standard as well, which I think it's a good practice. And actually, ESG has modeled and influenced these sort of agreements as well. So it's not only relevant in the context of M&As, but also in the context of finance agreements. Would you
Yes.
like to add something on that?
Yeah, yes, it is, and again, how finance institution and banks have approached this as a red flag due diligence or a checklist review led them with a high risk of having investments overlook, as we saw from KPMG results. More than 70% of opportunities to review cost and 50% of them to really invest more than 30% of the investment on the actual price. So I think it is wise for the financial and the bank sector also to understand if they're going to participate as big players as they are in M&As, have to look further, not to do these ESG reports as a greenwash opportunity, but to really to go further and to do the work on the site with the regulations and with the requirements to really acknowledge the opportunities and the actual costs that it will represent down the line.
I think you touched on something very important, which is the greenwashing, and actually the article that you referenced about the economist, I read it as well, and I think it was one of like the critiques of the signaling of the article about the greenwashing.
Yes, yes, and nowadays to talk about environmental and social issues without actually understanding migration from climate change effects, that this is happening already in all over the world, lack of water capacity on regards to actual processes, and the use of chemicals and management on companies that may have operated under different regulations and now have to face these changes. So basically, we have to do the work, we have to be thorough, and we have to have the conscience to really produce an added value on regards to an environmental due diligence and a specific an ESG perspective for this due diligence.
I think there are another couple of more questions.
Go ahead. I didn't saw them, so if you saw them.
Olivia, could you?
So then again, if we have no further questions, I think we're almost on the last minutes, and I would like to thank everybody attending today and contributing to this new discussion and contributing to these matters. And thank you very much.
Yeah, the same goes out from me. Thank you very much for being here, for your attention, and for taking part in this very interesting webinar. Have a nice day, evening, rest of the night, wherever you're located, and enjoy.